Morning, everyone. Welcome to the DC Court of Appeals. We have one case on this morning's calendar, two consolidated cases, it's a special sitting. The case numbers are 22 FM 129 and 23 FM 761, Kathleen D. Kenny versus David Michael Patrick Kenny. And we'll hear now first from counsel for Ms. Kenny.
Good morning. May it please the court. My name is Lydia Lawless and I represent Katie Kenny. I'd like to reserve 5 minutes for rebuttal if the court permits. Ms. Kenny did not intend to conceal her children on January 20th and January 30th, 2022. She did not call a well-known and respected, experienced family law attorney to find out how to kidnap or conceal her children. In the final weeks of her tumultuous marriage, Ms. Kenny did what any court would hope a parent would do. She contacted counsel to learn what her legal rights were and relied on the advice that she received. On January 20th and January 30th, Ms. Kenny followed the advice of her attorney, and in the 3 years since, she and her children have suffered beyond measure. Every determination made by the trial court in this case was infected by the erroneous parental kidnapping finding. The finding should be reversed. The final and temporary custody orders should be vacated, and this case should be remanded for consideration of the relevant custody orders without the taint of parental kidnapping. Before addressing why, under the framework this court established in CC, the acts on January 20th and January 30th did not constitute concealment, I'd like to address the mens rea element of concealment.
Can I ask you, I guess, before you do that, I am interested in an issue you've sort of touched on in your comments with reference to the concept of taint, which is there's an argument that the first appeal from the temporary custody order is moot because the temporary custody order is no longer in effect. And I gather at least a part of your response to that is implied by your argument that that finding tainted the final custody order.
Absolutely.
And can you explain the way in which you think it tainted the final custody order? Because the trial, your opponent relies on the fact that the trial court referred to those two incidents and said in discussing them that although whatever presumption, this is a paraphrase, but roughly whatever presumption against joint custody had been arisen had long since been rebutted, and your client had been following orders, and so really the issue was the best interest of the children. So why does that not eliminate the taint you're concerned about?
Because the finding of parental kidnapping persists. What the court, if the trial court had found in the final order, based on the evidence, having heard the full record of the intent of the parties, having evaluated the time frame and the actions of the parties in all relevant circumstances around January 20th and January 30th, and found that the parental kidnapping did not happen, did not exist, then we would agree that the temporary order is moot. But here, the trial court found that the parental kidnapping exists and said,
in the final custody order, you think the trial court said, by the way, that I am finding again that there was parental kidnapping and I'm relying on that in some way?
Correct. Because
where in the trial court's order does the trial court say I'm either of those two things? And the trial court does say I found parental kidnapping and I am aware that's on appeal, which seems more of a description of what happened than I am once again finding parental kidnapping and relying on it in determining where the best interest of the children lay, or any other way in determining the final custody order.
Because without a finding of parental kidnapping, the trial court would not have discussed the rebuttable presumption. And the court went into a discussion under the factor of interfamily offense as to how the presumption against joint custody had been rebutted.
I get that, but the trial court at least facially said whatever presumption may have arisen from that, this is again a paraphrase, so I'm not quoting, but whatever presumption may have arisen from that, I'm finding it no longer is in effect. It's not affecting my decision, is the gist of what the trial court seemed to be saying. So the mere mention of it to explain why it wasn't operative anymore seems not to suggest taint, but more an effort to set aside that earlier ruling.
So the finding that the presumption had been rebutted is different than the finding of parental kidnapping. And so that persisted, right? There was no renewed analysis of whether or not the parental kidnapping, the unlawful concealment occurred.
I certainly take your point, and maybe you're suggesting the other argument you had made at one point about mootness. I take your point that the trial court didn't, in the final custody order, say, by the way, I was wrong. There was no parental
Correct.
concealment, and therefore
Correct.
that let's just forget that. That's true. So when you say it persists, I know that one of the arguments you'd made at one point was that that ruling, unless expressly set aside in some way, can have collateral consequences. Is that what you're referring to now, or are you also, or are you saying the fact that it persists taints the final order just by its mere existence, even if there is nothing in the final order that states reliance on it?
So I think the answer to your question, Your Honor, is both. The argument, as I understand it, from the appellee is basically a harmless error assessment, saying notwithstanding the parental kidnapping finding, it ended up joint custody, so no harm, no foul. What we're saying is the parental kidnapping finding was the card upon which this house was built. But for the parental kidnapping finding, the Superior Court would not have asserted jurisdiction. Everyone agreed that the girls had not been in the district.
Well, you're not challenging jurisdiction now, though.
I'm just explaining how it
No, I understand
impacted
that.
every ruling.
But
So to say that it's no harm, no foul, a harmless error is not supported by this record. So the taint began with asserting jurisdiction. It then carried through with the temporary custody order, which then lay the foundation for the manufactured reality that was created by that temporary order, where for the first time, the girls were in the primary custody of their father.
I get that. I mean, I understand that line of thought, which is that, I mean, even if it were vacated right now, the reality is the temporary custody order predicated on a finding of parental concealment existed for quite a while and affected the situation on the ground, which in turn affects an assessment of the current best interest of the children. So I see that line of reasoning, but I'm not quite sure what could be done to fix that problem. Are you saying that the trial court, not only should we set aside the parental custody order, but we should send the matter back, the final custody order, by setting aside the determination of parental concealment, and then send it back and say, and by the way, when you're assessing the best interest of the children, disregard all circumstances that came to be only because there was the erroneous parental concealment order. It's hard to see how you'd unravel all of that. It would create some hypothetical world where there had never been a parental concealment finding, and the temporary custody arrangements would have been different, and then figure out what the best interest of the children would have been in that hypothetical world.
I think that's exactly what the trial court could do with fresh eyes and look at the facts of the case, look at the family's history prior to the finding of parental kidnapping, look at the fact that as of February 1st, 2022, prior to the determination of parental kidnapping, the trial judge said it was in the best interest of the girls that they remain with their mother in Chicago. And that after that determination, the court ordered that they be returned to the District of Columbia. Just as it showed, this court vacated.
Are you saying, I'll try to clarify whether you're saying one or two different things. One
Yes.
would be, on the hypothetical remand we're discussing.
Yes.
We would say to the trial court, don't look at the world as it really is. Look at the world that would have existed if there had never been a parental concealment finding, and then determine final custody based on the world that should have existed rather than the one that does exist. That seems like a pretty challenging idea. You might be saying something a little different. I'm just trying to figure out what you're saying.
So-
You could be saying, if the trial court understood that parental custody order, the parental concealment determination had been incorrect all along, the trial court might have viewed the final custody determination a lot differently. Might have look at the world that is, but be aware that it was created in part by an error, and that it should be assessed in light of that.
That's exactly right. That's exactly right. And the fact that if Ms. Ketty's actions did not constitute concealment, and she took the children on January 20th, 2022 home to Chicago, where they had lived as a family unit at all times prior to the trying to resolve the marriage in the district, then this negative inference that she has carried forward, that something she did was untoward or unlawful or otherwise contaminated, every single view of everything she has done thereafter. So it's not look at a world that doesn't exist. It says, look at the facts as they actually were. Consider all
Although,
of
can I
the
ask you,
circumstances.
you seem to be equating, assume that we agreed with you that in light of CC, what happened here was not parental concealment, and the trial court, not having the benefit of CC, incorrectly determined that. You seem to be suggesting that that would require the trial court to view your client's conduct as entirely blameless. And it seems like there's a fair difference between a determination that it wasn't criminal parental concealment
Sure.
and a determination that the trial court couldn't view it as a somewhat unfortunate course of conduct by your client at the time it was engaged in. So I'm not quite sure that the world the trial court would be in, if we were to agree with you, your client's conduct wasn't criminal, would be a world where the trial court would look and think your client had done nothing wrong.
Sure. So, and that's not what we're asking for, is not you saying that she didn't do anything wrong. It's that she did not intentionally conceal the children in violation of the criminal statute. There was no intra-family offense that was committed. So whether or not the court thinks that the fact of what happened, and the facts in this case are not in dispute, whether the court thinks that that fact is relevant to any of the other 17 best interest factors that it needs to consider, is something that the trial court can do. They can consider that fact as they would consider that fact in any other custody case, but not as an intra-family offense factor.
Is
So
is it fair to say that your theory of taint, the idea that the parental concealment finding was sort of a permeated,
Yeah.
to use a different metaphor, I guess, the final custody order. Is there anything specific in the final custody order where the trial court relies on that conduct in explaining how the trial court determined any of the relevant factors? There's obviously the explicit discussion where the trial court is setting it aside relative to a presumption against joint custody. But is there any place when the trial court's actually explaining, here is my balancing of all the factors and here's why I'm doing what I'm doing, where the trial court expressly in some way, or in your view, even implicitly in some way, relies on the trial court's on that conduct in the trial court's assessment of it as parental concealment?
So we only know what the trial court included in its findings, and it only analyzed the parental concealment under the factor involving intrafamily offense. That being said, it reiterated the findings of fact that undergird that determination that there was a parental.
Well, do you dispute those findings of fact, or?
We do not dispute the findings of fact, but the findings of fact are incomplete because they don't include the relevant evidence related to Ms. Kenny's intent.
Can I ask you one other question, but that is wrapping around a little bit to mootness? At least with respect to the collateral consequences line of thinking
Yes.
that is in some of your filings. One approach that is sometimes taken to orders that are sort of facially moot, which the temporary custody order here is sort of at first blush seems moot. It is, the state of affairs it created in the world is it's no longer operative as its own order. But when there are concerns about collateral consequences, one thing that the Supreme Court has done, and this court has sometimes done, is to not only dismiss an appeal from such an order as moot, but also as part of that remedy to vacate the underlying order to essentially avoid any collateral consequences of that kind. I don't know if you're familiar with that idea,
Yeah.
but at least relative to your collateral consequences argument, would that address those collateral consequences other than, I know it doesn't really address your taint problem,
Sure.
but relative to the collateral
so
consequences?
The first time we were here, that's what we were asking for, right? We were asking to vacate the temporary custody order. And, we had the theory that it was tantamount to an injunction, but since then, there's the additional collateral consequences. So yes, that would, to remove the determination of parental kidnapping is absolutely essential, but.
My point is there are two ways of doing that. One is to address it on the merits and say, if we agreed with you,
Correct.
the trial court was incorrect on the merits. This was never parental concealment. Another is to say the trial court entered that order as part of a temporary custody order. That temporary custody order has become moot during the pendency of this appeal. We're going to dismiss the appeal as moot. And because there was never judicial review of the parental concealment order, we're setting aside the order that found parental concealment. So it's like it didn't exist. They're just two different ways of addressing that kind of a problem.
Yeah, and I would agree with that. And I think that the collateral consequences in this case are extreme. You know, there is, how else is a parent that has been determined to have committed a crime get review, but to come to this court, right? And so for Ms. Kenny, and it's outlined in our papers, the stigma attached to her that she will carry as having been adjudicated a parental kidnapper. We've briefed for the court the professional repercussions that are specific to her as an attorney. They're particularly severe where the trial court has made an erroneous finding that she can and would move to the District of Columbia, where she is not admitted to practice law here. And that determination that she engaged in criminal conduct may prohibit her admission to the bar.
When
And-
you said, I agree with that, what were you agreeing with? Were you agreeing that it would solve the problem you're describing to have the underlying order vacated? Or are you saying, no, we really need you, court, to address this on the merits and conclude that there was no parental concealment? Which were you agreeing
So
with?
I was agreeing with Judge McLeese that that is an avenue that you can
I see.
find it moot and vacate the order. What we're asking for is the court look at it on the merits. In light of both the framework established in CC for evaluating the acts, but also the additional undisputed evidence that was part of the motion to reopen that was filed below that goes directly to Ms. Kenny's intent.
And as for any impact on your client, if she were to seek admission to the DC bar, for example, are
Yes.
you saying that you think that unless we look at it on the merits and hold that the trial court erred, that she would still face stigma or some impediment or some problem being admitted because of the earlier decision, even if it's been vacated?
Absolutely, because it hasn't been re-adjudicated. There's never been she's never been.
Well, to
exonerated.
vacate it is to cause it to have sort of never existed in.
Right.
To indulge that fiction, right?
Right. And I guess that goes to the third piece of the argument of collateral consequences, which is that it is continuously raised in the trial court below, with threats being raised by Mr. Kenny of reasserting, reminding her that she's a parental kidnapper, threatening to tell their daughter that she's a parental kidnapper. And quite frankly, when the girls are old enough to read and figure out what happened in their case, to have an adjudication, whether vacated procedurally or otherwise, I think that the only just thing to do is address it head on. I don't think it's moot. I think that it continued through the final order. I think the trial judge in the final order found that there was a parental kidnapping and said, notwithstanding that finding, the rebuttable presumption has been overcome. If the judge had said there was no parental kidnapping, there would have been no discussion of the rebuttable presumption, and there would have been no analysis under the intrafamily offense factor.
And to follow up on something you said earlier to Judge McLeese, you mentioned that had there not been the parental kidnapping finding, or the facts that eventually led to that finding, the trial court never would have asserted jurisdiction. And so the outcome might have been different. And what I'm trying to get to is what you have in mind in terms of sort of unraveling the taint. That's the question you were discussing with Judge McLeese. And I'm thinking that part of what you would say is the taint is the fact that the result was that the girls live in the District of Columbia, that they've been with their father for more time than they would have been with their father. Are you suggesting that if we were to send this back, or upon sending this back, we would need to direct the child court not to take into account the girls' living situation over these last couple of years? Or how does that
No,
play
not
out
at
in your
all.
mind?
I mean, that's clearly for the court's consideration in the best interest factors, absolutely. But what was not given a fair shake in this was the time prior to the parental kidnapping determination, right? And one of the things that happened in this case was in ordering on February 11th that the girls be returned to the district. The trial judge found that he was returning the family to the status quo. And he's maintained that the status quo was the district throughout this litigation. And so Ms. Kenny has never really gotten a fair shake on the status quo for these girls was with their mother. It is undisputed that prior to them being returned to the district, they had never spent more than 2 nights alone with their father. And so this analysis of where in time the court should present status quo is something that needs further exploration.
I mean, that seems to conflate things though, right? Like the status quo, if we're talking about a geography, doesn't have to do with a person per se. So why are they wrong to say that the status quo is that they've been immediately living in the district, though also the court should have acknowledged they had a home in Chicago. This was not an absconding to someplace they'd never been before.
Right. Because, and I guess it goes, I guess it is conflated, right? Because one is where physically they were located, but the other is what the family's history was. And I don't want to get too far into the elements or the factors of custody that really aren't before the court that we haven't appealed, but I think this goes to Judge Thompson's question about how do we unravel it. She has to have the opportunity to present her case without this rebuttable presumption that attached to her on February 9th, 2022.
So I know it's kind of a redundant question you've been asked from a couple different angles, but help me understand. I understand your point of the idea of this rebuttable presumption. It permeates everything, even if we found it rebutted or not found, even if the trial court found it rebutted. It was there to start with, so it has to have some effect. What's the effect? Where was the negative impact on your client directly in the terms that were decided from that?
So the effect was twofold. The effect was first that she was denied joint physical custody on February 2nd, 2022.
Mm.
Okay, and the second is the effect of the final order where the girls are ordered to remain in the district is that she has 1 weekend a month with them during the school year.
So why, if the presumption was rebutted, are those things necessarily linked in the final order? It seems like the trial court has to make a decision, whether there's this reasonable, one person's in Chicago, the original home area, not saying finding any particular facts here, but saying you lived in Chicago, we now have people living in Chicago, you lived in DC, we now have people living in both. The trial court's got to find some way to split that up. Why does that mean that rebuttable presumption, which it found rebutted, resulted in that, in the division?
So one of the things I'll point the court to, excuse me, is that in the final order.
Do you need water? Do you have some there?
Yeah, I've got some.
Okay.
That was the problem. So it was a wrong pipe situation.
Hmm.
You want to take a minute if you need it.
Absolutely.
Sorry. Is that if you look at the final order, when the factors are weighed, they're either neutral or the factors are weighed not mom versus dad, it's Chicago versus DC. And that's what was set up, right? That's what was set up by this temporary order, is this focus on the location as opposed to the parent. These girls were 15 months and 5 years old at the time that they were returned to the district, right? They didn't have a status quo. They didn't have, friends in DC. They didn't have a life in DC. And in fact, in the final order, the judge found that because of their age, it would not disrupt them to be relocated to Chicago. So the judge was focused not on who is Miss Kenny and what was her relationship to those girls, and who was Mr. Kenny and how has he provided. It's focused on, since the beginning, Chicago versus DC.
That seems more like an argument that you could have raised from the final custody order, that its focus was just off. And that the trial court gave undue weight to one of the issues and was kind of failed to fully appreciate the entire mosaic and give appropriate weight to appropriate factors. But that hasn't been an independent argument that was raised.
It hasn't been, and I recognize that that's an abuse of discretion standard. And so we focused on, in the final order, the erroneous finding that really undergirds the evaluation for all the different factors.
Right. Well, I mean, it seems like you have two main. You have a procedural argument about the trial court's failure to reopen, and then you have what seemed like maybe 2 points about the final order, one of which is the what you describe as unsupported statements about the mother's plans if the children were located in DC. And then also you have this argument that is a sort of a harmlessness type argument about the effect of what you view as the incorrect parental concealment determination. And just back on the last of those two things, it's in some ways a variant of the question Judge Howard was asking, which is maybe it would help if you could be as concrete as possible, but like looking at any of the factors the trial court was weighing as the trial court was going through the best interest determination. Like, what would your specific argument be about why, if the trial court had understood that there really never was any parental concealment, as you think, the trial court's analysis would have and should have been different? So like pick a factor and say, look, if the trial court had understood that, it was operating from a false premise of parental concealment, its analysis would have been different.
That's a really tough call, right? Because of, and I don't want to, I don't know. And I think that that's one of the problems with this case. And that's why I think it needs to be vacated and remanded, because the trial court sits as the finder of fact in the first instance. And the trial court needs to reevaluate all of the facts, not disregard the reality, reevaluate all of the facts, all of the evidence without any presumption. And so how it weighed on the credibility determinations, we don't know. How it impacted whether the court weighed more heavily the post-temporary custody arrangement versus the established family unit where the father lived in the District of Columbia on his own accord and would come home and visit the girls on occasion. We don't know that. And that's why we're asking for the remand. There's nothing that I can point to specifically, Your Honor, to answer your question, to say this is the fact that was incorrect that the trial judge relied on. What we know is that it is interwoven throughout the findings of fact. The judge specifically stated that he only made findings of fact that he found to be material, right? In his footnote, he said that he did not adjudicate and did not make findings on all allegations by the party, that he only made findings as to those that were material. So clearly he thought that those facts were material. So how they impacted the individual factors, I don't think I can, candidly, I don't think I can answer that, but I think that that is exactly why it needs to be remanded.
So just looking at the footnote, I think the footnote's worded a little bit differently, which says I didn't decide every allegation, because not every allegation is material. That's a little
Correct.
bit different from saying everything I am deciding is material.
I
It's a little bit different.
I suppose, but to say I didn't find allegations that I found not material infers that the findings that he did make were material.
I mean, he has the date of their marriage, for example. I doubt that was, material, like the exact date, which day in August it was. So there's plenty in there that probably wasn't load bearing to the best interest determination, but I know you're well over time. So I don't know if you have a sentence or two you want to wind up with.
I have a lot of sentences, but I understand that I'm well over time. I think that just focusing the court on Ms. Kenny's intent and the evidence that was proffered as part of the motion to reopen clearly undermines any allegation that she had the requisite criminal intent to conceal her children. And that she carries with her, having been adjudicated a criminal, has severe collateral consequences. And the only way for her to get meaningful review is for not only that order to be vacated, but for this court to issue an opinion finding that her acts on January 20th and January 30th did not constitute concealment, and that she did not have the requisite intent, both based on her statements that she made those days, that she intended to avoid conflict, that she was returning home to Chicago, and that she wanted to shield the girls from an escalating and tumultuous relationship, right? And so where she had equal custody rights to those girls, she was entitled, and she should be she should receive the presumption that she acted in those girls' best interest, which was to take them home and to shield them from increasing toxicity. So.
Thank you, counsel. We'll give you your 5 minutes for rebuttal.
Thank you.
May it please the court, Leah Ramirez on behalf of appellee David Kenny. So I'd like to start off with the primary points that this court was focused on, which is what is really the impact of these findings. And as we've heard, the factual findings and the background and the backdrop isn't contested, right? These facts still existed as they were with or without a parental concealment finding. And so the end result of that was the trial court appropriately going through the statute, making its finding that it had already found in the temporary custody order about an inter-family offense. And we've all, well, at least Ms. Kenny has conceded that parental concealment is an inter-family offense. And then ultimately awarding the parties joint custody and saying repeatedly that this finding has not, I believe the trial court's words, at least in the transcript, were this was a moment in time for Ms. Kenny. This is not the thing that is going to define her and to define this case, because what happened in the temporary custody order is the trial court returned the children to the status quo. And I know we defer in terms of what we say the status quo is, but the status quo is returning these children to the district. Everyone lived here. I mean, everyone agreed to live here. It wasn't a surprise that they were all living here as a family unit in a condo that they were, or sorry, in an apartment that they were leasing, where the child was going, the older child was going to school, where they had a nanny. And this was not news to anyone that returning them to the district was the status quo. I think Ms. Kenny wants to sort of reinvent what the immediate status quo was, and that's just not what the court did in the temporary custody order.
Can I ask you, I guess, on the mootness piece of the puzzle?
Sure.
While your opponent was up, I was discussing one approach to orders that seem facially moot but might have collateral consequences, which is to not simply dismiss an appeal like from the temporary custody order as moot, but also to vacate the underlying temporary custody order. Do you have an objection to that remedy?
Well, I do object to the fact that I do think the facts, even under CC, do amount to parental concealment. But if this court were considering the approach of vacating the temporary order, the findings were made in the final order as well. And so they can be reviewed there. And I don't.
You think the trial court in the final custody order reiterated its parental concealment finding and that that's reviewable directly in the appeal from the final order?
I think it's what Your Honor said earlier, which is the trial court said it found in the temporary custody order. So in terms of your mootness question, does vacating resolve an issue about collateral consequences? Well, I'm not of the view that there is proof of collateral consequences. I mean, we have a decision that was made now almost 3 years ago. And it's speculation that there were any collateral consequences to Ms. Kenny. The end result in terms of the custody situation, and that of course wouldn't be a collateral consequence.
Right, but unless you wanted the collateral consequences, what interest would you have in having the temporary custody order unvacated?
Your Honor, what we don't want is for the court to have to reopen a 3-day trial and to undo a custody order that ultimately awarded the parties joint custody and was in the children's best interest. That's primarily what we don't want. I hear you on, does it benefit us to have a parental concealment finding? I mean, that's not the goal here, but I do think under CC, it does amount to parental concealment. And I would like to talk about that some.
No, I think it'd be good to turn to that. So this case is different from CC in some respects. And CC, I was a member of the division in CC, and it's I think a difficult case of line drawing. But the overall thrust of CC, one could say, is in settings where there's no custody order, controlling the rights of both, the custodial rights of both parents. There is at least some latitude where the parents are disagreeing about what should happen with a child for self-help that isn't criminal. And why do you think this self-help falls on the criminal side of self-help in a setting, again, where both parents have full custodial rights and there's no order controlling how they exercise them?
Sure, Your Honor, great question. Well, I think the lines do need to be drawn, and I agree with, all of the hypos that we're not trying to capture here surprise parties and things like that. I mean, they do have equal rights to the children, but what they don't have is exclusive rights to the children. And so taking a child, I mean, if we look at what happened on January 20th, she took the children and hid them from the father in a car, in a vehicle, and purposefully, and to her admission, did not disclose their whereabouts, their destination, their location. And I think that fits squarely within what this court said in CC. Whisking a child across state lines without the knowledge of the other parent could be considered concealment if the other parent sought the child.
But
And the
it's a little
facts-
grayer here, isn't it?
Sure.
Like she didn't whisk the child away to New Mexico, some state where they didn't have any sort of connection to. And you talked about the immediate status quo, which that's all DC seems to be in this. It seems like there's a real debate whether Illinois and it's not for us to have here, but whether Illinois or DC was even the appropriate venue. Like, was there any doubt once it became apparent that she was heading out, that that's where she would be going to, or what makes this clearer cut?
Sure. Well, I suppose it's not the doubt on Mr. Kenny's part, it's the intent on Mrs. Kenny's part, or sorry, Miss Kenny's part. But
So
I
then
don't
why
believe it
shouldn't we
makes-
have considered as she urges us, or why shouldn't the trial court have considered as she urges, that she was acting on advice of counsel?
Well, the advice of counsel, number one, I'm not sure that that's a defense in this context. I don't believe the cases relied upon in the criminal context carry over to an inter-family offense finding in a family law case. And number two, I think you have to look at the procedure in which that was raised, which was a motion to reopen 18 months after the temporary custody order. And none of the cases are even close to analogous to warranting reopening the case at that point.
Well,
on
we'll
that
jump you
front.
further around. If we really had to dig deep into this and talk about the parental rights, you say there's not an exclusive parental right, there's a joint parental right. I don't really see where the trial court weighed those rights extensively when it made that original finding. Wouldn't that on its own be reason for us to remand it back down if it matters so much, and ask the trial court to really consider who had the superior parental right at that time?
Well, I don't think anyone had a superior right at that time, right? That's why we have these pre-custody order situations. And I think, what's important is if we're not going to capture some facts, then we rendered the entire subsection A completely void, right?
Yeah, but I mean, back to Judge Howard's question about how this case is different from where the parent who's exercising self-help to remove a child whisks the child away to some unknown location. If Miss Kenny was trying to conceal the children other than in a relatively fleeting way, she picked a very poor way to do it, because she took the children. The plan was all along, apparently undisputed, she was planning to take the children back to their other joint home. That's not a very good way of hiding the children, it seems.
Well, I think it is disputed. I think what she said earlier in the sort of marital breakdown was, I'm going to take the children and keep them from you. It wasn't, I'm going to take the children and take them back to Chicago. It was, I'm going to keep them from their
Well,
father.
that was your client's testimony, I think, right? And was there a
Correct.
finding as to whether that was credited or not credited?
I believe the trial court's finding was that she was going to take the children from him, not that it was back to Chicago. I think Miss Kenny has argued in her briefs that that was the finding.
It's now in the temporary custody order or in the final custody order? My question was ambiguous, so I'm not criticizing you. I was just clarifying which one we're talking about.
That, Your Honor, I believe appears in the final. Actually, I don't want to answer that because I don't know offhand.
Well, would you agree? Let's assume for a moment, imagine that the trial court had found, I'm not saying the trial court did because I'm blurry on in the two orders exactly what the trial court said about Miss Kenny's intent with respect to the transportation of the children when she exercised self-help the first time. But assume that the trial court found that she intended when she took the children and drove away on the 20th, I guess it is, to take them back to the other joint home in
Mhm.
Chicago.
Mhm.
Would you agree that's not a very effective way of long-term concealment of the children? I mean, it's taking them back to the obvious places you would look.
Right, Your Honor. If Miss Kenny had said prior to getting in the car, I'm taking the children back to Chicago. I mean, under
Well, I thought
CC,
we were looking at Ms. Kenny's intent, not your client's state of mind.
right, we are. But if she had disclosed the children's location, I mean, we're talking about the act there of
Well, so
concealment.
that's what I'm trying to, I guess part of what I'm trying to figure out is your focus, is your idea that the trip, your client not being aware exactly where the children were during the trip, or maybe being somewhat uncertain about where the trip's destination was. And again, the issue isn't directly your client's state of mind, but again, Ms. Kenny's intent, but her actions and her understandings of what your client's state of mind would have been are sort of part of her intent, I guess. Is the concealment during the period of the 8 hour, like when was the concealment and what exactly do you think it consisted of? Focusing it now on the first of the two incidents.
Sure. On the first instance, I would say those 5 hours where Miss Kenny admits that she didn't disclose the children's location to their father when he repeatedly asked and sought the children, which is what this court found in CC. That was the period of concealment. At the point where she said, we're a few hours from the Chicago condo, that was around 8:55 PM. I think the concealment arguably ends at that point, right? Because we know the destination, the location, and where to find the children, most importantly.
And do you think it's criminal? How quickly do you think? Do you think it was unlawful for Ms. Kenny to leave with the children without your client's consent? Was that itself concealment intrinsically, or was that not concealment in and of itself?
to leave without consent? So do I think she can take the children under a pre-custody order context back to Chicago? Yes, I think it's factually problematic, but yes. What I don't think she can do is then hide the children and their location from their father.
And I mean, in CC, there was some period where the father was unaware of the precise location of the children, which was more, I think, in the order of an hour, if I'm recalling correctly. And we treated CC as not on the criminal side of the line. So you think that the difference, is one of the key differences, how many hours it was of uncertainty, or I know there are other suggested differences, but is that a critical one in your view, or is that less critical?
So I think in CC, there were a lot of differences, right? You found that the father there had emailed, that there wasn't really a question. Grandmother had seen the child go with mom. Mom had a visitation that weekend. I mean, I think those circumstances are very different from a family unit that's living together, that dad's arriving home at 3:30, and right before that, you decide, or I suppose an hour or so before that, you form an intent to leave and hide the children. If Miss Kenny just said where they were going, I don't think we'd be here with respect to January 20th. And I also think January 30th is even more problematic, which is, I've told you where I'm going.
And you think, just to be clear, you think that since it's Ms. Kenny's intent, if she testified, I wanted to take the children away, I assumed he would realize I was taking them to Chicago, and I didn't think there'd been any mystery about that. So I wasn't trying to hide them. I was just trying to take them to the other joint home. If that testimony had been given and credited, would you agree there would be no criminal parental concealment?
Well, I don't know that she could say that with respect to Mr. Kenny. I mean, she said in her text messages around when this was unfolding, I just need things to calm down, right? That to me suggests I'm, at a
Well,
restaurant,
that's
I'm
a way of saying
somewhere
it shouldn't
else.
be. I mean, that's in a way sort of resisting the hypothetical, because that's saying really on this record, such a determination to credit her testimony might have been clearly erroneous, and maybe that's right. But so to step back and get out of that and be more hypothetical, if the facts were like this case, except there was, or let's just say two parents with a child in common, and they're not getting along. One of them takes the other to some other joint home without giving any information about location, but says, I'm taking the child away.
Mhm.
And then imagine there's testimony about what was that parental concealment and what was your state of mind. And imagine that the parent who took the child away said, it's true, I didn't write down where I was taking them, but it just didn't even occur to me. I wasn't trying to hide the children. I just wanted to take the children away. And I assumed that the other spouse would correctly infer that I was taking the house to the other shared location. If that testimony were credited, would you agree that's a defense to parental concealment?
Not a defense, Your Honor. I think it goes back to what you all found in CC, which is, did he seek the children at that point? So if it was just unknowing to Mr. Kenny,
I'm just asking, assuming, again, the hypothetical I just gave, and then imagine that the other parent comes home and reads a note that says, I don't, I've taken the children. It was a crime of parental concealment committed on those facts. If the trial court credits the testimony that the intent of the parent who took the children was not to conceal the children, but instead to take them away to a known location.
mhm. Yeah, yes, Your Honor, if the intent was to not conceal the children. Yes, but I think Miss Kenny did intend to conceal the children. I mean,
Was it-
she
Uh,
withheld that information for 5 hours and said other things and talked to family and friends and everyone but Mr. Kenny. I mean, I don't think we'd be having the conversation if Miss Kenny didn't intend to conceal the children. And then I also think we get to, if I may, January 30th, which is,
Before you go there, can I just ask you what you were starting to say? You said you said something about she might have been at a restaurant. Where were you going with that comment?
sure. So my point was, the way this unfolded is Miss Kenny was saying in a text message, I just need things to calm down. She wasn't saying, I'm currently having my sister drive across state lines to go to Chicago. Mr. Kenny, from his perspective, didn't know where the children were. It could have been that, she just needs things to calm down and she's at a restaurant, waiting for the time to pass or whatever the case may be. So it was to Judge McLeese's point that Mr. Kenny was seeking the children and didn't know where they were at that point in time.
So you would say there was concealment there, leaving him wondering whether they might have been in a restaurant or somewhere like that.
If he's seeking the children, yes, I do.
And if he was seeking the children and Ms. Kenny simply didn't look at her phone,
Mhm.
she didn't answer the phone, she didn't answer a text message, she was simply quiet until she got to Chicago. Would that have been concealment?
Well, then we get to, I think, her intent, right? And I kind of look at that akin to a mistake or an accident or something. Let's say she lost her phone entirely. I don't think she's intending to conceal at that point. But we know that she wasn't driving. We know the entire drive. And we know that she talked to other people on the phone. And we also know that she sent text messages to Mr. Kenny, just not disclosing the location of the children.
Is it relevant at all that that Ms. Kenny's location could have been discovered by someone because she had her cell phone? Her message was, the children are with me.
Mhm.
Someone, maybe not Mr. Kenny, I don't know, someone, her cell phone carrier, her provider, someone could have discerned where she was with the children. Is that relevant at all?
I mean, I don't think so. I mean, I will say to that point, Mr. Kenny did try to find the car's location through the GPS, but was unsuccessful there. And that was one of the part of the testimony and one of the findings the trial court made. But I don't know that an ability to GPS locate a cell phone would negate the.
Yeah, I just wonder, when you think about parental concealment more generally, sort of at least the scenario that comes to my mind is stashing the children somewhere where no one has the ability. If you don't tell them that the kids are with Aunt Mary, no one would ever know, you know, no way of tracking them. But here we have children who are with a parent who is with her cell phone. And it makes me wonder whether that really is what the legislature intended by
Well,
concealment.
Right, and I understand the court's point. I mean, we do have to draw some line somewhere.
And in Cho, one of the facts, as I recall it, and correct me if I'm wrong, is that the grandmother or the aunt or whoever the relative was saw the child
Mhm.
get into the car. But it seems to have been purely by accident. If she hadn't looked out the window, perhaps no one would have known where the
Right.
child was. And yet the fact that she knew seemed to be important to the analysis.
Right, I would agree that that did weigh on the court's analysis, at least my understanding of it in Cho, in CC.
So on the other side of that, though, if we were to consider we're in this, what they call in the CC argument, the Wild West, or I'm just gonna call the self-help regime, before we have a pendente lite order, to what extent should we also be considering the idea that, well, if I go and I tell someone where I'm going, they have the ability to frustrate that?
Mhm.
I mean, it was clear by the time they were in Chicago and we got around to what was the second incident. And correct me if I'm wrong on the facts here, Mr. Kenny showed up with the police to take these children back.
So I don't look at it as frustrating. I look at it as, are we giving, well, number one, are we deterring self-help here, which I think we should be deterring? And then number two, are we giving the other parent the opportunity to afford themselves available legal remedies? And one of which is to involve law enforcement, not for, any malice or anything like that, but just to make sure everyone is on the same page.
And you're going a little further beyond where I want to focus, though. If I am someone and I feel like, without deciding any of the facts on this, we're not the trial court, that, okay, I've got a negative situation. I've got to get myself and the kids out of it.
Mhm.
And I am now moving out, but if I let someone know immediately where I'm going, they can come find me, they can come stop this. And we have joint parental rights, which is kind of gets back to one of the other questions I was positing earlier. You know, the trial court, it feels like to me, should have had to figure out, and perhaps with the help of CC would have focused on that, balancing the parents' rights in the individual situation. It seems like a very deep question of fact, but how much should we consider when we're looking at the lack of notice or the delay from the original time to the notice, as you're noting these 5 hours, the potential for that to defeat the purpose of the parent who is technically exercising rights, even if we don't want to encourage self-help, which can definitely go down a slippery slope.
Mhm. I think the statute is great in that regard because it outlines the reasons why you could do things like that. I mean, it does cover domestic violence situations, rightfully so. And so the taking parent in that situation has remedies and they have a structure to follow that's outlined very clearly in the statute, which is within 5 days, you're to file something saying, here are all the reasons I did what I did and I was authorized to do it. That just didn't happen here. I mean, what happened on January 30th is Miss Kenny hid the children at a restaurant so that she could continue to exercise exclusive rights again. Again, Mr. Kenny had equal rights and
So how do we
insisted.
balance those equal rights?
I'm sorry, Your
So
Honor.
how do we balance those equal rights? It seems to me like what we're trying to get at here is not really where there's a clearly established exception or defense under the statute, but when parents are just exercising their rights here for better or for worse.
I think the trial court has to balance them. I mean, I agree with the CC decision that you do have to balance these conflicting rights because they are conflicting in that context.
Can I ask you with help on line drawing and moving back to the the 20th, the incident on the 20th? If Ms. Kenny, I guess it was a text where she first communicated, I'm taking the children. If she had said, I'm taking the children to Chicago, would you think that, and then had refused any further communication and had in fact taken them to their joint residence in Chicago, would you say parental concealment or not?
I think it's hard to argue in that context that she's hiding the children and she's.
Although, just to change a little bit, imagine he'd said, oh, what road or which highway are you on?
Right.
And and she'd refused to answer and later said, I didn't want him to know exactly where I was. Would that be, I mean, how granular is the
Right.
information about knowledge of location that children have to be?
I look at where can I find the children, right? Does Mr. Kenny know where he can find the children? And in
Or
that.
if he said, I'm getting my car right now and I'm a faster driver than you and I'm hoping to come, see my children, what highway are you on? And she said, I'm not telling you that.
Mhm.
He said criminal parental concealment.
I think it depends what she does after that point in time. If she's still going to the Chicago condo, And she's already disclosed that's where the children can be located and that's their location.
Eventually, that's not their location at the time. He's
Right.
demanding better and more up-to-date and more granular location about, location information.
Right. If she had disclosed the children's location, we have a hard time arguing that.
Well,
where
that's
they're
not their location, that's their destination. really.
Right.
It's like I'm taking them to a place, that's a destination, not a current location.
Well, no, I still don't think that she needs to disclose the longitude and latitude. I mean, I think he just needs the ability to know where to find them. And if we're looking at January 30th, I think they are just two different situations, but he didn't know where to find them. I mean, this court said in CC, just knowing generally the children are somewhere in Illinois isn't enough. I mean, taking the children and hiding them at a restaurant is just,
Right.
you know, when he was trying to exercise his right.
Focusing on the second incident, and changing it a little bit and making it hypothetical, if parent A and parent B are having a dispute about what should happen to the children physically, like who is gonna be in physical control of the children, and parent A has physical control of the children, and parent B says, where are you right now? I'm gonna come and physically take the children.
Mhm.
And parent A says, I don't want you to do that. They're here with me. They're safe. Here's a picture of the restaurant we're in, but I'm not going to give you directions to where you're going to physically take the children away from me. Criminal parental concealment.
If they're hiding the children from the other parents.
Well, you say,
Yes.
so is that, in your
Yes.
view, that is hiding them?
Yes, I think that is hiding them. I mean, I think, you know, what would happen on January 30th is Mr. Kenny said, I'm not just coming to anywhere. I'm telling you, I'm coming to the condo. And I'd like to see the children, our children. And she took and hid them. And, you know, that was intentional. I think there's no dispute that her actions were
And
intentional.
you would agree, though, that she had no obligation to produce the children for him. If she'd said, we're driving around Chicago and right now we're on this intersection and I'm still driving, ask me again, I'll tell you where I am then,
Yeah.
but I hope you won't catch me. He doesn't have an obligation to produce the children. She doesn't have an obligation to produce the children for him, or do you think she does?
I agree. No, I agree. She does not have an obligation to produce them. She just can't, on the other side of it, hide them from him.
But in the hypothetical I just gave, which is, you know, she answers every question, which is, here's where I am right now, but I'm not going to be here in 2 minutes because I'm not, I don't want to be where you are.
Mhm.
Is that hiding, or that's hiding by not producing, or, because there's kind of informational hiding and there's physical hiding, and I'm trying to, I guess, pull the two apart a little bit.
Well, I think both qualify as concealment, both informational and physical hiding. In that context, she disclosed where they were. It's to the court's point in CC, right? I'm not saying there's a obligation to continually apprise another parent of their location at all times. But if a parent is seeking a child and says, I'm at the Chicago condo, I want to see the children, and then she goes into hiding, I think that is problematic. I do. And I think it's encouraging self-help.
On a little bit of a different train, I think that the trial court noted the testimony that Mr. Kenny was a good dad. That was not a dispute. But the email seemed to indicate that Ms. Kenny wanted to leave because she didn't want the children to witness further hostility between the parents. Apparently, there had been some of that recently. What I'm trying to get to is the question of whether or not a parent could be justified in concealing a child if what she was trying to do is not to protect the children physically. There's no physical danger to the children, but if what she's trying to do is to protect them from witnessing hostility between the parents. What's your answer to that? Is that a defense to
Sure. So
concealment?
it's a great question, Your Honor. I was thinking about this sort of otherwise authorized by law. I suppose if she had some threat of imminent harm, right, that could potentially qualify as.
Well, certainly physical harm,
Right,
sure.
physical
But what
harm.
about, I just don't want my children to witness another scene between us. It's
Right.
not good for them.
I still don't think you can hide the children at that point from the other parents. They're expressly enumerated defenses, physical harm, whether it's otherwise authorized by law. I don't believe she can. Number one, I don't believe that that was her purpose. I mean, I think she said also in the emails, I want to make sure he can't keep the kids in DC. And so she was worried about trying to get the children to Chicago and have exclusive rights over them there. And then on January 30th, you know, as Mr. Kenny's there, she has him served with papers for an Illinois custody filing and tells him that he can't see the children unless he submits to jurisdiction and a custody order there. I mean, I think you have to you do, and you should look at the purpose of the hiding and the concealment, and apply, you know, a common sense approach to that. But I think just to answer your Honor's question, if it doesn't fall under one of the enumerated reasons why you can conceal a child, then it's not authorized.
You're also way over time, not your fault. We haven't really discussed at least one thing that I'm interested in getting your response about, which is the statements in the trial court about Ms. Kenny's intent to move to DC if the children were physically situated in DC. Ms. Kenny argues that the trial court said that repeatedly and that in fact the evidence was to the contrary. Do you agree that that's not what the evidence was?
No, Your Honor. So I think what Ms.
You don't agree? You think there was evidence that she was willing to move to DC if the children were located there?
There was in the record, Ms. Kenny said in multiple motions, and this was post temporary order context, that she, you know, rightly always wants to live where her children are. She said that.
This is in motion. These are statements in motions or that
Yeah.
evidence at the hearing?
So there was testimony at the trial that she always wants to live where the children are. That's at A2, the supplemental appendix 276. Sorry, A2 is the second appeal at 276. And in the post temporary order context, she also said in multiple motions, she would not live where her children were not. She told the court she plans to remain in DC while the case is adjudicated. I think also she asked for alternative relief if the children were living in DC, which was a shared custody schedule. And she testified also that she would come back primarily for the whole summer and just stay here while Mr. Kenny could have primary custody under her proposed schedule. So I think the trial court's
I asked
finding
you
that.
I was a little surprised by your answer a minute ago because I didn't recall in your brief an argument that in fact the record supported the trial court statements on that topic. Is that a point that you made in your brief or is that a point that you're making for the first time here?
The point made in the brief was that Ms. Kenny conflated the ability to travel to DC and be in DC, which I think the record does support, with an expected relocation, that she would relocate to DC. So they were finding, I think also if you look at the trial courts.
Just to put a pin in that, so are you agreeing that the point you're making now, that you were making a minute ago, which is actually the record supports the trial court finding that Ms. Kenny did plan to relocate to DC if the children were physically located there, that the argument that the record might provide support for that there was this piece of testimony and some motions, that's a point that wasn't in your brief, is that correct?
I am not aware of that express point being in that brief, Your Honor. But I would say if you look at the trial court's opinion as a whole, I mean, it did support that the trial court knew that Ms. Kenny would be in Chicago and Mr. Kenny would be in DC. And so.
That's a separate line of thinking, which is although the trial court 3 times said, as though it was a fact that the trial court was finding, that Ms. Kenny would move to DC if the children were physically located there. You're saying that those are kind of stray comments and that you can tell from the trial court's order that the trial court understood that the situation was the opposite.
That's correct, Your Honor. I do think the trial court understood very much so that Ms. Kenny would be in Chicago. But also if you look at Ms.
Well, if the
Kenny.
trial court knew that for sure, then why did the trial court even create alternative? I mean, it's kind of a mystery. If the trial court was certain either way, you wonder why the trial court had both, scenario A and scenario B. That seems a bit of a mystery for both sides, but.
Well, that was actually proposed by Ms. Kenny.
Right.
That was Ms. Kenny's testimony, that she would propose alternate schedules. And that in her proposed findings of fact, I actually don't think they're in the appendix, but she asked for proposed schedules, proposed alternate schedules And so the trial court actually awarded, the relief she requested. If there are no further questions, thank you.
Thank you, counsel. Ms. Lawless will give you your 5 minutes in rebuttal.
I'd like to start, Judge McLeese, with the question that you just asked. There is no evidence to support the trial judge's finding that Ms. Kenny would move to the district if he ordered primary physical custody in the District of Columbia. There is no evidence of that.
Your opponent just cited some testimony, some references in filings, which isn't necessarily directly evidence, but then also at least one piece of evidence. What's your response to that particular piece
So
of
she
evidence?
cited that she testified that she always wanted to live where her children lived. That doesn't mean that she would move to the District of Columbia. She wanted to live in Chicago with her children. She proposed 2 alternative custody arrangements. One of them wasn't if the girls live in Chicago. One of them, it was if the parents live in the same city. So it wasn't the girls live in DC, it was if both parents live in the same city, which is a very different recommendation than here's what will happen when I move to DC. If Ms. Kenny was going to move to DC, she wouldn't have litigated this case because they could have just continued on the split schedule that they had. There is no evidence, and there is evidence to the contrary, that she repeatedly testified that she could not move to DC. She could not maintain her position at the law firm, and quite frankly, the family couldn't afford it. So her statements in motions during the temporary order and the final order that she was making it work while the case was adjudicated should not be held against her. That should not be read in to a conclusion that she stated she would relocate to the District of Columbia. And so the reality of that erroneous finding is that all of the factors cited in our brief that were implicated by this, where the court says, I find it's in the best interest for for the parents to have as much exposure to one or the other, that favors the District of Columbia. Those are all erroneous because what the court was saying was essentially, this is the only way that the girls will have lots of access to both parents. Based on the determination, his belief, his erroneous belief that Ms. Kenny would move to the District of Columbia. She never testified to that, and there's no evidence to support that finding. Just a few other things that I wanted to note is I don't think, and I think something in reading the prior briefs and watching the first argument and then also watching the argument in CC, this court struggled mightily with how you define parental rights in this pre-order period, right? And are you judging a moment in time? Do you say an hour is okay, but an hour and 5 minutes isn't okay? And I don't think that that's the correct analysis. I think the analysis is exactly for determining whether or not the act of concealment occurred is to follow the framework set up by CC, which is, was the parent concealing the location? And was the parent obligated to continuously apprise the other parent of the location? And so one of the things we highlighted in our brief is in CC, there was I guess an understanding that when the email was responded to an hour later, that satisfied, that was the end of any allegation of concealment. In that email, the mother in CC never said where she was, and she never said explicitly where she was going. And so similarly to this case, what she said, what the mother said was, the child is with me. And that is exactly what Ms. Kenny did. So if you're evaluating that framework, concealing location, the child is with me, that is the location, right? That you're not required to continuously apprise because.
Well, that can't quite, I mean, assume that parent A, where no custody order exists, and parent A takes physical custody of the child and leaves parent B and is gone who knows where for months at a time and promptly responds to all inquiries by saying, don't worry, the child is with me. You would agree that at some point that becomes parental concealment, criminal in character, or maybe you don't, I don't know, but would you agree that at some point after 8 months where parent B has no ability to have any custodial connection to the child and no idea where the child is other than to know there's a parent other than to know that the parent A is claiming that the child is with parent A.
Right, because yes, I would agree that that is a different circumstance. What I'm saying is the analysis applying CC here, the facts line up exactly, right? The father knew where she was going. The father knew where to locate the children, right? That is the point. And when the court analyzed the legislative intent, it was a focus on the location of the children so the children could be located. And so where they were, what route they were taking from New York to DC or from DC to Chicago is not material, because you want the parent to be able to get out of this self-help regime and access the courts where the children are located.
Do you know off the top of your head, I was just looking and I in the temporary custody order, I didn't really see very clear findings on some of the factual issues we've been discussing about what your client's state of mind was, about what the Mr. Kenny might have known or inferred about where she was taking the children, or I know there was some testimony by Mr. Kenny that at some point your client had said, I'm going to take the children and you'll never see them again, or something like that. And I don't know if there was a clear factual determination by the trial court about whether that happened and what that meant about your client's state of mind.
So
Do you agree that there really isn't a lot of detailed factual finding on some of those topics?
there's no factual finding on those topics. Ms. Kenny's intent has never been evaluated by a trial court. And it has certainly never been evaluated with the benefit of the fact that she was relying on the advice of counsel, right? Before the father returned home to the rented apartment on January 20th, Ms. Kenny emailed her lawyer and said, should I tell him we're headed to Chicago? And her lawyer said no. Hours later at 6:53, her lawyer advises her, let him know you and the kids are in Chicago when you get there. How can someone intend to conceal when they are following the advice of an attorney who holds herself out to be a specialist in this area of law in the District of Columbia? So Ms. Kenny has never had the benefit of that. And so whether or not that negates the intent element of criminal concealment, or whether or not that is an affirmative defense that may exist, we argue it's both. It doesn't have to be. The point is that she did not intend to conceal the children. And where her explicit statements about what she intended to do, she intended to return home, she intended to avoid conflict, as Your Honor said, and she intended to seek the intervention of the court, which is exactly what she did when she returned home. And that's exactly what you want parents to do. You want to de-escalate, you want a cooling off period, you want to remove children from conflict, you want to take them home, and then you want to seek the court. And so, for the acts of concealment, I understand we can parse that and we can parse the timeline, but I think the court doesn't need to get there based on the evidence or the lack of evidence that Ms. Kenny had criminal intent. One fact that I do want to highlight, because I know I'm out of time, is that on January 30th, when she sent a picture of the children at the restaurant, there's undisputed testimony. The father testified he recognized the restaurant, he knew where the girls were. And I don't think that, well, I'll just leave that at that. I also think that the defenses in 1023 is that otherwise authorized by law means something other than fleeing imminent physical harm, right? Because that's one of the elements, that's one of the defenses. And otherwise authorized by law is something different. And here our contention is Ms. Kenny, without a order directing her otherwise, was authorized by law to take her children home to their condo in Chicago and seek help of the court in Cook County. Thank you very much.
Thank you to both counsel for your briefs, for your arguments, and the case is now submitted. We'll stand in recess.
All right.